This is the state court case number RCL/300/2020. The state versus Fazila Bibi Khan, Seedat being the applicant, and Lenasia court number 2. Today's date is the 6th of May 2020. Appearances, presiding officer. It's Mr. Mata, public prosecutors, Mr. Mkuno, interpreter, accused English speaking, and for the defense today we have Mr. Ibrahim, that is on the court road today for further evidence or shipping this bail application.
Yes, Mr. Ibrahim. Applicant Seedat.
Thank you, Worship. On the last occasion, the court directed certain queries which it needed satisfied in order to properly consider the issue of bail. I have, in support thereof, Your Worship, prepared a written affidavit signed by the accused, and with leave of the court, I will read it in, Your Worship.
Yes.
In the Regional Court for the Regional Division of Gauteng held at Lenasia, in the matter between Fazila Bibi Seedat and the state, this is a supplementary affidavit. I, the undersigned Fazila Bibi Seedat, do hereby make oath and state as follows. 1. On the 14th of April 2020, my legal representatives made application to the above honorable court on my behalf in an attempt to secure my release on bail. In support of this application, I deposed to an affidavit in which I endeavored to satisfy the honorable court that the interests of justice permit my release on bail. Hereinafter referred to as the first affidavit. To date hereof, I have not been able to obtain my release on bail. On the 29th of April 2020, the court postponed my matter to the 6th of May 2020. The learned magistrate directed that I depose to a supplementary affidavit in order to address certain issues that were unclear to the honorable court during my bail application on the 14th of April 2020. I accordingly deposed to this affidavit in order to address the concerns raised by the learned magistrate in an attempt to further amplify my case and satisfy the honorable court that the interests of justice permit my release on bail. Unless otherwise stated or appears from the contents hereof, the facts contained herein are all within the scope of my personal knowledge and are to the best of my belief both true and correct. During my appearance in court on the 29th of April 2020, the learned magistrate sought clarity on the following specific points. 5.1. On whether the business referred to in paragraph 6.2 of the first affidavit in fact exists, and what proof besides the accused say-so is there that the business existed or even still exists. I address this under the heading, whether the business exists herein below. 5.2. On what do the travel regulations, that is the change thereof, have to do with Seedat and Patel's money? Was it used to book travel, accommodation, etc.? And what proof is there thereof? I address this concern under the heading, effect of travel regulations herein below. 5.3. On why there is no refunds or delay of refunds since Mia's letter, which was attached as Annexure B to the first affidavit. On whether if this was not a scam, and if this was not a scam, why was a promise, why not a refund? I address this concern under the heading refunds herein below. 5.4. On the version of the investigating officer in respect of the circumstances which occurred at the time of my arrest, which was testified upon by the investigating officer on the 14th of April 2020. Specifically in relation to the allegations made by the investigating officer that I hid and had to be found when they attended at my premises to effect the arrest. Additionally, the learned magistrate sought clarity on the involvement of Farid Kara in the period prior to my arrest. This concern is addressed under the heading, circumstances surrounding my address herein below. On the matter of the passports, I specifically in relation to the verification of the passport, I will address this concern under the heading passport verification herein below. I will address each of the learned magistrate's concerns individually, and whilst doing so, I may adduce evidence based on new facts. Where I do so, I submit that it should not prejudice me in this bail proceedings, as I am uncertain why these facts were not adduced in the first affidavit, which was prepared by my previous legal representatives. I have since the first affidavit mandated by current legal representatives who currently advise me in these proceedings. Under the heading, whether the business exists. In respect of this concern, I submit that the business does in fact exist. In support of this submission, I attach here to a copy of the search works of New Heights 1379 Pty Limited, marked as Annexure FBS1. It can be noted from Annexure FBS1 that New Heights 1379cc is a close corporation incorporated as such in terms of the laws of the Republic of South Africa with registration number 2003-030-256-23. It can be noted further that I am currently the sole member of the said entity. I submit I utilized New Heights 1379cc to trade as a travel agent, and it is common cause that I operated as a travel agent for many years. In amplification of this, I attach a copy of the International Air Transport Association certificate, in terms of which I am certified as an approved agent, marked as FSB2. I have been in the travel industry for a cumulative period of 33 years. Effect of the travel regulations. Paragraph 12. In respect of this concern, I respectfully submit that the change in travel regulations resulted in an increase in the rate payable for visas by a person requiring the same to travel. This resulted in some customers electing to proceed with the booking and pay the additional costs and proceed to travel, while some customers elected to apply for a refund. Paragraph 14. The monies paid by Seedat and Patel were indeed utilized towards securing travel arrangements. In support of this submission, I attach here to proof of the booking and proof of the payment made in respect thereof as annexures FSB3 and FSB4 respectively. The payment reflected in annexure FSB4 was made in advance in order to secure flights on behalf of the entire traveling group, which included Patel. With regards to Seedat, I attach here to a spreadsheet and confirmation of the flight reservation which was secured and paid for in corroboration therewith marked as annexure FSB5. In amplification of my submission that the monies paid by Seedat and Patel were utilized to secure the bookings, I also attach here to a copy of credit card payments made in advance to hotels on behalf of passengers, which included Seedat and Patel, marked as annexure FSB6. It can be noted from annexure FSB6 that in excess of 160,000 Saudi riyals was expended in order to secure these bookings on behalf of the passengers. At the time, this loosely translated to a rand value of approximately 620,000 rands. Due to the fact that I am currently incarcerated with no access to my records, my legal representatives have had limited access to the records, which would further reflect the booking secured on behalf of all the passengers, not just Seedat and Patel, as well as the proof of payments in respect of payments made in advance or in anticipation of these bookings to the relevant service providers, including flights to Saudi Arabia. I submit that the above sufficiently illustrates that the bookings were secured on behalf of Seedat and Patel, and that the funds were expended by my business in order to secure these bookings. Under the heading Refunds, paragraph 19. In relation to this concern, I respectfully submit that monies were expended in the manner articulated herein above in order to secure the bookings on behalf of the complainants. It is pertinent to note that the funds were paid to secure bookings were paid to service providers in the Kingdom of Saudi Arabia. At the time when my attorneys of record, Mahmoud Mia attorneys, transmitted a letter which was attached as Annexure B to the first affidavit, I had a reasonable apprehension that the service providers from Saudi Arabia would reimburse my business with the monies expended on behalf of customers to secure their bookings. Paragraph 22. To date hereof, we have not been reimbursed by the airlines and hotels, and in this regard, I submit it is common knowledge amongst travel agents in the industry that no refunds will be processed without them first having been reimbursed by the service providers who were paid in advance. I respectfully submit that in light of the fact that I have attached proof that the bookings were secured on behalf of the passengers and proof that payments were made by my business in order to secure such bookings, it is unfathomable that I intended to scam anyone. In the premise, I submit that the undertaking which was given was bona fide, and that I would not have mandated an attorney to communicate such an undertaking had I not had the reasonable apprehension that I would receive a refund from the service providers which were paid in advance on behalf of customers. Under the heading Circumstances Surrounding My Arrest, paragraph 25. I am aware that this Honorable Court is of the view that I hid away at the time of my arrest when my arrest was being implemented in order to avoid my trial. I respectfully submit that this is not the case, and I will articulate herein the circumstances surrounding my arrest, and I will provide valid reasons for attempting to hide when my arrest was being effected. Paragraph 26. During about the beginning of March 2020, I was contacted by the investigating officer in this matter. I was informed that a case had been registered against me. At this point in time, I was in Durban, KwaZulu-Natal for medical treatment. Paragraph 27. I immediately telephonically contacted my nephew Riaz Malik Ahmed, hereinafter referred to as Riaz, and requested him to contact the investigating officer on my behalf whilst I was in Durban. Paragraph 28. Riaz attended to the Lenasia police station during or about the middle of March 2020 and arranged to meet with the investigating officer in the matter. It was agreed with the investigating officer that I would surrender myself in respect of this matter when I returned to Johannesburg. Paragraph 29. On the 26th of March 2020, the nationwide lockdown began. I was uncertain as to what this meant in respect of my undertaking to surrender myself. I, however, assumed that the arrangement made with the investigating officer still persisted and I would be able to surrender myself in respect of this matter. I proceeded to comply with the nationwide lockdown. Paragraph 30. On or about the 6th of April, and whilst I was in quarantine within my place of residence, a group of people attended to my residence. These individuals were dressed in civilian clothing and were not in marked police vehicles. They presented themselves in an aggressive manner and demanded that I open the gate immediately. I immediately contacted Mr. Farid Kara, a private security person who is well known to me. At this juncture, it is important to note that I never referred to Mr. Kara as a private investigator, but rather that the investigating officer referred to him as the same. The reason for me contacting Kara was that I was fearful that the individuals that were outside my residence were attempting to gain unlawful access to my premises. Kara advised me not to open the gate to my premises until he arrived. However, before I could inform my husband of Kara's instruction, he had attended to the gate and allowed the individuals access to the premises. At this point, without having yet consulted with my husband and fearing for my safety, I impulsively attempted to hide in my domestic quarters. It later transpired that the individuals were in fact police officers, that the investigating officer was part of this group. This was unbeknown to me when the group initially attended to my gate and aggressively demanded entrance to my residence. I respectfully submit that had I known that the individuals were police officers, I would immediately have granted them access to my premises and surrendered myself. I did not believe that they were in fact police officers, in light of the fact that my nephew Riaz had already arranged for me to surrender myself in respect of this matter. I thought that this arrangement still persisted at the time of my arrest. I attach here two confirmatory affidavits of both Riaz and Kara marked as annexures FSB 7 and FSB 8 respectively in support of my submissions contained herein insofar as it pertains to them. It is pertinent to mention that on the 2nd of November 2019, I attended to the residence of one of the complainants in the matter, Aslam Seedat, at the request of his wife Zakia Seedat. On my attendance at their residence, which is situated in extension 13 Lenasia, I was confronted by three male individuals who were unknown to me. I was then assaulted by these male individuals on the instructions of Zakia Seedat, who is one of the complainants in this matter, and the men proceeded to punch, kick, and slap me several times until I managed to flee from the house. The incident was witnessed by my sister, Fazila Bibi Khan, hereinafter referred to as Razia, and my husband, Ghulam Sabi Seedat, hereinafter referred to as Ghulam, who attended the premises with me. The three unknown males followed me out of the house and proceeded to physically assault my sister Razia and my husband Ghulam. A case was registered at the Lenasia police station in respect of the assault under case number 18 of November 2019. The matter is currently being investigated. I pause to point out that if this was a scheme of theft and fraud, I would never have attended to the house of Zakia Seedat in order to explain the problems associated with their travel arrangements. I attach a copy of my WhatsApp conversations with Zakia Seedat in support of the aforementioned allegations, wherein she requested my attendance at her premises as Annexure FSB 9. Additionally, I attach a confirmatory affidavits of Razia and Ghulam, marked as annexures FSB 10 and FSB 11 respectively, in which they confirm the contents of my submissions insofar as it pertains to them. In conclusion, I submit I do not have any intention to evade my trial and in any way attempt to defeat the proper functioning of the criminal justice system. Under the heading Passport Verification, in respect of this concern, I am aware that the Honorable Court seeks confirmation that my passports are legitimate and that the surrender of my passports are a true reflection of my bona fide intentions not to abscond and reflect my intention to attend my trial on each and every occasion. I attach here to a document which my legal team has managed to obtain from the Department of Home Affairs, which reflects that my passports are legitimate, marked as Annexure FSB 12. It can be noted from Annexure FSB 12 that there is only currently one active passport. There are two other passports which are not yet expired, but which are endorsed under the Code 10 under Passport Status column. I submit that Code 10 means that the passport is full and cannot be utilized further. This is apparent from page 2 of Annexure FSB 12. In light of the above and in light of the fact that I have surrendered my active passport to the investigating officer in the matter, I respectfully submit that it is clear I have no intention to abscond. I further undertake not to attempt to apply for any additional travel documents, and I undertake to face any charges preferred against me. Under the heading Personal Circumstances and Interests of Justice, I respectfully submit that this affidavit, read together with the contents of the first affidavit, is sufficient in order to satisfy this Honorable Court that the interests of justice permit my release on bail. I will not repeat hearing the submissions made in my first affidavit in relation to whether the interests of justice permit my release on bail. I submit that the Honorable Court should read my first affidavit in conjunction with this affidavit when making this determination. I do, however, wish to amplify my submissions insofar as my personal circumstances are concerned. I have been in custody since the 6th of April 2020. I'm currently being kept in the hospital section of Johannesburg Prison, where I have been diagnosed with hypertension. Whilst I am grateful for having been confined to the hospital section, I submit that I am still in a precarious position. This due to the fact that my health has been deteriorating since my incarceration. Additionally, it is of great concern to me that cases of COVID-19 have been confirmed in the Johannesburg prison, and given my age, deteriorating health, coupled with the fact that I have pre-existing underlying medical conditions, this places me squarely in the more susceptible risk category to contract COVID-19. I also wish to point out that prior to my arrest, I financially supported my two minor grandchildren fully. The names of my grandchildren are Umair Khan and Jihan Khan. They are 5 and 7 years old respectively. I attach here 2 copies of their birth certificates, marked Annexure FSB 13 and FSB 14 respectively. Whilst my grandchildren reside with my husband and I am their main caregiver. I respectfully submit that I have articulated herein that there is no risk of me absconding. I respectfully submit that the interests of justice do not require that I remain in custody pending the outcome of my trial, which I am informed can take many months. I intend to attend court religiously and faithfully on each and every occasion to which this matter is postponed until its conclusion. Furthermore, I submit I will abide to any conditions which this Honorable Court may impose. In this regard, I undertake to sign in at the Lenasia police station as many times a week as may be required of me. I have been advised and further respectfully submit that my continued incarceration will prejudice my preparation for trial. Furthermore, my family will suffer immensely and will be deeply prejudiced as I assist in making ends meet in the household. I respectfully submit that on the basis of the above, read in conjunction with the first affidavit, I have discharged the onus placed upon me, which is to satisfy the above Honorable Court that the interests of justice permit my release on bail. With regards to the amount I am able to afford for bail, I have managed to raise an amount of 10,000 rands. Wherefore, I pray that bail be granted with the conditions as the court deems necessary. It's dated at Lenasia on the 6th of May 2020 and signed by the deponent, the accused in this matter, and properly commissioned by the South African Police Services here at Lenasia on the same date. Your Worship, Annexure FBS 1 is the New Heights CIPRO search, which details the registration of the company and the company documentation. Annexure FSB 2 is the IATA registration certificate, And one can see from Annexure FSB 2 that she was registered, certified as a registered accredited agent from as early as 13th of June 2007. Your Worship, Annexure FSB 3 is the booking confirmations for some of the complainants in this matter. And one will see that the person referred to as Zakia, her name is also mentioned in here. The following is an Al Baraka proof of electronic payment to Saudi Arabian Airlines on the 2nd of July 2013, together with the group fare agreement which she was required to sign in order to confirm the arrangements and deal with Saudi. One will also see that that agreement is attached. And if one goes to Annexure FSB 5, one will see that the spreadsheet reflects the details of the passengers that were traveling, including the Seedat families and the various members of the Seedat family. Annexure FSB 6 is numerous credit card receipts for amounts paid within the Kingdom of Saudi Arabia to confirm the bookings. Annexure FSB 8 is a confirmatory affidavit of Farid Kara. Annexure FSB 7 is a confirmatory affidavit of Riaz Malik Ahmed. Annexure FSB 9 is the text messages referred to with Zakia Seedat, who is one of the complainants in this matter and the accused in this matter, which led her to arrive at the complainant's place of residence. Annexure FSB 10 is a confirmatory affidavit of Fazila Bibi Khan, a witness to the assault. Annexure FSB 11 is a confirmatory affidavit of Ghulam Seedat, who is also a witness to the assault. Annexure FSB 12 will be the Home Affairs inquiry, which demonstrates the passports issued. One will have a look at the column, which is the fifth column on to the right, which indicates the code 10, and the second page of the said annexure reflects that code 10. When a passport is endorsed as code 10, it means that the passport is full while still valid. Annexure FSB 13 is the unabridged birth certificates of the minor children, two minor children referred to, marked as Annexure FSB 13 and FSB 14 respectively. Your Worship, with leave of the court, may I hand in the affidavit? Your Worship, in addition thereto, and I was only given this morning, it wasn't included, but I'm going to hand it up for the court's purposes, is booking confirmations showing departures of some passengers during December who elected to travel, as well as several proof of payments from Nedbank, Your Worship, reflecting some passengers who have already been refunded. I believe this would be useful to assist the court in making a proper determination on the matter.
The contents of the affidavit as far as it relates to you. Now, if this affidavit is admitted into the recorded evidence of this bail application, it can also be admitted by the trial court during trial if matters go that far, and be used against you during such trial. Now, do you want this bail affidavit to form part, in fact, the bail affidavits and annexures thereto to form part of the recorded bail evidence, even though it can also be admitted by trial court and be used against you during trial? No, the question is not whether I understand or not. The question is whether do you want these documents to form part of the record of the bail evidence, which may be admitted and be used against you in trial? Has the state seen the affidavit?
No. Even though I haven't seen it, I've listened to it, and I'm opposed. The state is objecting to it being admitted.
Yes.
And the objection of the state is premised on the following reasons. Inasmuch as the role of the court during bail application is inquisitorial in nature, meaning the court can play a very active role and request both parties, the state and the defense, to adduce certain evidence in order to assist the court in receiving or in making or arriving at a decision. That invitation in its own, an invitation by the court to both the state and the defense to adduce specific evidence in order to assist the court in clarifying this aspect, is not an invitation to the state and the defense, Worship, to have a second bite at the cherry or to relieve the pinch of the shoe. Now, I've listened to this, to what is contained in the affidavit, and fortunately, in the morning, I had an opportunity of listening to the previous proceedings that were held in this court on the 29th of April when I was not here, because this matter is covered by the media. So I had an opportunity to get into their website or their Facebook page and listen to what transpired on the previous occasion. Now, what my colleague has done today is to have a second bite at the cherry or to relieve the pinch of the shoe. He has adduced new facts, which is irregular at this stage. The court said, I want clarity on this aspect. The court indicated that I want the defense to indicate why Mr. Kara did not assist the applicant pertaining to her handing herself over at the police station. When did this relationship between Mr. Kara and the applicant start? Was it during the investigation of this matter, or was it after the case had been opened? The court did not require evidence pertaining to birth certificate of the child or of her children, Worship. The court did not require information pertaining to the cases that were open against the accused or in favor of the accused. The court did not require or from the defense to be furnished with WhatsApp conversation between the accused as well as the complainant. The court did not require to be furnished with proof that last day in November, some of the people that paid to the applicant's account did go on this trips. The court did not require that. So what the defense has done during this bail application, or them adducing further evidence, they're trying, with all due respect to my Leonard colleague, they're trying to sneak, I'll say with all due respect, they're trying to sneak evidence through the back door. Evidence that was not required by the court, which is an irregularity. Because if the court were to allow, say, I'm accepting this affidavit even though it contains new fact, that will if this matter goes to the higher court, it will vitiate the entire proceedings. They will say, however, the proceedings were irregular in the lower court because the court permitted the defense to adduce new evidence prior to them bringing an application to do so. With case of state versus Ndwele, and as well as case of state versus both Supreme Court of Appeal, they're clear. They lay down guidelines of what the defense needs to do. They say there must be an application based on substance. Why the defense wants to adduce new evidence? You can't just simply stand up and then, in addition to adducing evidence that the court wanted you to clarify, you introduce new facts without bringing an application to reopen your case and adduce new evidence. You can't just do that, because if the court were to allow this to be done, besides the fact that it will amount to an irregularity, the state will stand up and say, what is good for a goose is also good for a gander. The state should also be allowed to adduce new evidence. Then I need to call the investigating officer and adduce new evidence. And we'll never reach the finality of this matter. I refer this court to one case that dealt with bail application. The finality that needs to be reached swiftly when it comes to bail application. It's also a Supreme Court of Appeal case. It's a foreign case. Magistrate Stataheim versus Mashia. The court said the following in that case. It is evident that finalizing an application for bail is always a matter of urgency. And if bail is refused, the decision can always be appealed. The right to a prompt decision is thus a procedural right independent of whether the right to liberty actually entitles the accused to bail. But the language finalization of bail application. If the court accepts such an evidence from my colleague, new evidence, without having had an application or entertain an application brought by my colleague to adduce new evidence, that will amount to an irregularity, as it was stated in the case of State versus Ndweni and State versus both Supreme Court of Appeal. They said there must be an application before court first by the defense saying we are bringing an application to reopen our case so that we can adduce new evidence and state the reason why this evidence was not adduced during their case, when they started their case. The state will submit that this affidavit handed it by my Leonard colleague contains new fact, and it should not be admitted by the court. Admitting same would be procedurally wrong and will vitiate the entire bail proceedings if this matter were to go to the High Court. Because another High Court will find that clearly in the lower court they did not follow a proper procedure in proceeding with this matter, specifically on new facts that were accused by the defense. And they have to send the matter de novo to be heard by another magistrate, and it will take away the urgency that applies in all bail application. The state will submit that the said application brought by my Leonard colleague or the affidavit my Leonard colleague intend to hand should not be granted. The court should veto it. If they still want to adduce evidence or clarify, or adduce evidence to clarify the aspect the court wanted clarity on the previous occasion, they can always call the applicant. Applicant is before court. They can always call the applicant, put the applicant in the box and clarify those aspects, rather than hand an affidavit that has new facts. The state will submit it all due respect. The said affidavit contains new facts, and the court should refuse to accept the said affidavit, because accepting same will amount to an irregularity. No further submission by the state.
May I proceed, Your Worship? Your Worship, I'll try and be as concise as possible, Your Worship. I'm going to start first, Your Worship, with my colleague's submission regarding an application to reopen the defense case in respect of the bail application. It's unfortunate that my colleague was not in court on the day, or that he had listened to the recordings, because he would have heard first that that was an issue that was dealt with and discussed before the open court, Your Worship. Your Worship, the second issue, Your Worship, in satisfying the court's queries and the further queries of the court, and this court has an inherent power where it's unable to make a decision if insufficient facts are placed before it, to postpone an accused bail application in order for such facts to be put before it. This court went further, Your Worship, and stipulated the facts that needed to be placed before this honorable court. In satisfying this honorable court's queries, it became necessary to present certain facts which were left out for reasons unknown to me as a current legal representative, Your Worship. Your Worship, it appears as if my colleague has not quite grasped the concept of onus and burden in a Schedule 5 bail application. The fact that the defense has the onus and burden to start, Your Worship, does not in any way exonerate the state from rebutting those facts that are presented by the defense. It does not mean that in a Schedule 5 bail application, because the defense bears the onus to start, that the state should then sit back, Your Worship, and not present any evidence. Your Worship, there are certain pertinent facts which are important to this court, which have been placed before this court. And what is important, Your Worship, is common cause, having listened to my colleague's address, that there is not a single rebuttal of any fact that has been placed before this court. Not in respect of the investigating officer's version of events, nor in respect of the assault that happened. In respect of the WhatsApp conversations that my colleague is objecting to being attached, it's relevant, because on that incident and on that day when the assault took place is the very reason why the accused feared for her life, and is the very reason why the accused chose to hide in a back room when she was uncertain as to the identity of the individuals that were entering the premises. Why have we submitted supplementary confirmatory affidavits? Because the investigating officer, who, as my colleague is quick to state, the applicant should give evidence, who gave evidence before this honorable court, deliberately did not disclose to this Honorable Court that he was visited by the nephew of the accused and an arrangement was made to surrender the accused to the police station. None of those facts were placed before this Honorable Court by the investigating officer, and the state is clearly not intending to rebut that version of the accused, or has not chosen not to. The investigating officer could have been recalled by the state. I seen him here walking down the corridors this morning, but the state has conveniently chose not to rebut those facts. Why, Your Worship? Those facts are directly relevant as to the circumstances under which the arrest was effected, as to the circumstances under which it was alleged that the accused was a flight risk because she chose to hide at the time of her arrest. And that has now clearly been explained, Your Worship, without any rebuttal from the state. In addition thereto, Your Worship, several other important factors, like for example, Your Worship will recall that the defense and the state were both asked to assist in the verification of the passports. It was not just the defense that was tasked with this matter. And Your Worship, to date, as we stand here today, the state has not given any indication of what attempts they made to verify the passport. So one would assume, Your Worship, if the defense had not done it, there would be no evidence, Your Worship, to confirm that here today. Fortunately, the defense, Your Worship, took the lead from this Honorable Court, and the verification was done in the best way that the defense could do. And that information is now before this Honorable Court. Your Worship, in conclusion, this Honorable Court is tasked with a bail application. To restrict the accused's freedom, Your Worship, would be a drastic measure, and the court does not seek to make such decisions lightly in any event. And any evidence that is placed before this Honorable Court that will assist this court and enlighten this court and properly ventilate this matter should be considered by this court. No reasons have been suggested, apart from the fact that my colleague is suggesting that I ought to have brought an application to reopen the defense case in respect of the bail application and to advance reasons why the new evidence is now being tendered. I believe, Your Worship, that the affidavit that has been read into the record today fully advances the reasons why that was not tendered before. But what is pertinent is my accused advances no reasons why the interests of justice would not be served by admitting the information in this affidavit today, as this would greatly assist this Honorable Court in coming to a fair, properly ventilated decision. My colleague also does not attempt to even try to explain why he chose not to seek, rather to stand the matter down, consult with the investigating officer, confirm the correctness of the version of events as set out in the affidavit, but rather chooses simply to try and refuse, to convince his court to refuse to accept the supplementary affidavit. I submit, Your Worship, the cases that my colleague has referred to being in Ndwandwe and Botha have no relevance in this matter. The case that the court ought to consider, Your Worship, is, where's that? The court will just bear with me, Your Worship. In this matter, Your Worship, should be State versus Branco, 2002, Volume 1, SACR 531, Western Cape Division, where it was simply stated, and the court said, the court drew the conclusion that in considering a bail application, Your Worship, the court should obviously look beyond just the paper aspects of a bail application, Your Worship, and the court should actually attempt to assist the accused where possible in granting bail where no reasons are advanced as to why an accused should not be granted bail. Your Worship, that is the only relevant case. The other cases in Ndwandwe and Botha have no relevance to the matter, as there were bail applications on new facts for reasons completely different. Those facts were not available to this Honorable Court. This court is seized with the current application. The application has not been finalized, and therefore, Your Worship, it's well within our right to bring it, especially in light of the queries raised by Your Worship, as the court pleases, unless Your Worship would like me to address him on any other specific aspect, Your Worship.
My colleague, he misses the point. I'm not yet dealing with the substance of what is contained in the affidavit. I'm saying the procedure we are following is wrong. We are procedurally wrong. We admit this affidavit that will amount to a procedurally irregularity. The law is there. A court has discretion, I concede. However, precedent is there to be followed. Lower courts are not precedent setting. We look at the higher court's judgment. What do they say in cases like this if you want to adduce new evidence? They say bring an application. Not just out of the blue, hand in new evidence. Bring an application. That's the procedure that has been laid down by these cases I've referred to. Bring an application, indicate substance, why you want to reopen your case. Not just stand up, address the aspect the court wanted to be addressed on, and you add further new facts. You must bring an application. We're a creature of statute. Follow the statute. Bring an application to reopen your case. State grounds why you want to reopen your case, and then proceed. If the application to reopen your case is granted, then proceed and adjust new evidence. New evidence is not for the taking. Adjusting of new evidence is not just for the taking. You apply. The court has discretion, I accept, but you must apply. The case of Blanco is irrelevant when it comes to this aspect. It does not deal with the procedural irregularity. What I'm saying is that we follow a wrong procedure. The matter goes to the High Court. They'll vitiate the entire proceedings that we've conducted, the number of days we've wasted proceeding with this matter. They will say, we're procedurally wrong. We should not have done this. There are case law that are laid down pertaining to the procedure you must follow. My colleague has not followed, with all due respect, my colleague has not followed the procedure. Luckily, again, probably grateful to the media that is covering this matter. This is what transpired. My colleague said, does that mean I shouldn't bring an application for reopening my case? On the previous occasion, I was watching it in the morning. The court said, as long as it's evidence pertaining to the aspect the court wants clarity of. The court is not blessed with a foregoing foresight of seeing what is going to happen in future. The court did not anticipate that the defense will adjust so much new fact in their case. The court expected or anticipated the defense to address the issues the court wanted to be addressed on. The court gave guidance. For instance, the court said from the state, they want us to clarify pertaining to the issue of passport. If I come today and say, in actual fact, last week we've just arrested the accused in Cape Town, he appeared, the value of that case where the accused was appeared, it's maybe 2 million. That would be new fact. The court did not want clarity on that. I'll be taking advantage of the court's discretion. That is why the state is saying, my colleague is just trying to have a second bite at the cherry, Your Worship, and introduce evidence through the back door. The court cannot promote the introduction of evidence through the back door. And I say this with the greatest respect. There's a procedure for introducing new evidence. My colleagues know it. He should follow that procedure and then will adjudicate this issue pertaining to the new evidence. The state will submit that affidavit in as much as it contained new evidence. The court should refuse to accept it, Your Worship. No further submission by the state.
Reported in the media. That is a fundamental first flaw that he's making. You ought to have first listened to the record of the proceedings, because that would have enlightened him and ventilated the issue properly, Your Worship. As the court pleases, Your Worship. I stand by my submission.
Take a short adjournment. There's a judgment I want to take from my office.
He doesn't want to stop. Lie down. Come on, just lie down.